Minister.
Mr. Deputy Speaker, I thank the Members of Parliament, Mr. Chun Shou Mao, Mr. Louis Ng, Engineer Dr. Lee Biwa, Mr. Saktiandi Supat, and Associate Professor Walter Tessera for their comments and also their support for the bill. Let me address the questions that have been raised. First, on tax deductions for qualifying donations and extension of the BIPS, which was raised by Mr. Louis Ng. The 250% tax deduction for qualifying donations was extended for 3 years until December 2021 to continue to encourage the spirit of giving. Total tax deductible donations received by IPCs from corporate and individual donors have risen by 26%, from about 687 million in 2008 to 866 million in 2016. So this is a very encouraging trend, and we hope more can continue to come forward to give. Many donors contribute out of passion and heart for the community, and it's not just because of the tax incentives. Having said that, the 250% tax deduction that we offer today is already one of the most generous tax deduction schemes worldwide. Countries like Hong Kong, America, and Australia provide only 100% tax deductions for corporate and individual donations. So we do not think it's necessary at this stage to make this tax deduction permanent. We will continue to study ways to encourage giving, taking into account the needs and maturity of the charity sector, the impact of tax deductions on donations, and the tax revenue foregone. We also need to consider how the different deductions and reliefs benefit taxpayers in different income tax brackets. Unlike tax deduction for qualifying donations, BIPS is a relatively new scheme that was first piloted in the second half of 2016 to encourage businesses to support their staff to volunteer. We extended the scheme for 3 years in 2018 until December 2021 as the take-up was encouraging. We want to encourage corporate giving, but we remain open to existing new or different ways of doing so. So let us monitor the progress of this scheme and study how best to further encourage corporate giving. Mr. Ng asked if the scheme could be expanded to allow for the wages of sole proprietors, partners, and shareholders, essentially the business owners, to be claimable. The rationale for the scheme is for our businesses to encourage their employees to contribute their skills and time to the IPC. Therefore, the focus is on the employees. In fact, the business owners of the company already benefit from the tax deduction given to their business when their employees volunteer in the IPCs under the scheme. Mr. Ng also asked if the scheme could be extended to charities which are non-IPCs. Currently, only IPCs can issue tax-deductible receipts for qualifying donations. This is so because IPCs are subject to stricter standards in regulatory compliance and governance compared to the non-IPC charities. We apply the same standards for BIPs as wages and related expenses associated with volunteering are also eligible for tax deductions. And we will continue to review how to make this scheme accessible and relevant to encourage corporate volunteering. So that's on the tax deductions for qualifying donations, as well as the extension of the Business and IPC Partnership Scheme, or BIPS. Next, let me touch on tax deduction for motor car-related expenses for private hire car drivers, PHC drivers. As many members mentioned just now, many of you have spoken up about the need for the tax deduction. We have taken in the feedback, reviewed this extensively, and we are now making these changes. The tax changes update our tax regime in view that taxi and PHC drivers now provide similar point-to-point transport services. Engineer Dr. Lee Biwa asked about the difference between part-time and full-time PHC drivers and whether some of them would have difficulties apportioning their expenses correctly. Indeed, this is the reason why IRAS has taken time to listen to feedback from different stakeholders. And instead of coming up with a scheme that may be complicated and difficult to administer, we have decided on a tax deduction based on the deemed expense ratio set at 60% of gross driving income. This ratio is a proxy for all expenses incurred that incurred to earn driving income. So those who, and it applies to both full-time and part-time drivers. So those who drive more would claim more, while those who drive less would claim less. Nevertheless, drivers who still opt to claim tax deduction based on the actual amount of expenses incurred can do so if they wish to. Right? And if they want to do that, they will need to keep proper records of the expenses and ensure the correct apportionment of its expenses between that incurred to earn the driving income and that for private use. But I would imagine with this deemed expense ratio, many drivers would consider using it for their convenience and for ease of compliance. I would also like to clarify in response to the question raised by Engineer Dr. Lee Biwa that currently self-employed delivery persons are already allowed to claim tax deduction on expenses incurred on using motorcycles or commercial vehicles such as vans. So that's already claimable. Mr. Saktiandi shared about residents who are examples of residents who are PHC drivers who face difficulties in paying their income tax for the year of assessment 2018 as well as their MediSave contributions. The tax changes will help them on a prospective basis, but for those individuals who may have difficulties with their existing obligations, I would advise that they contact IRAS and CPF board, and the agencies will look into having a suitable installment plan to assist them with their obligations, be it for tax or for MediSave contributions. Mr. Saktiandi also asked about the regulations in respect of PHC drivers. He asked about age limits, medical health certifications. All of these really come under the purview of MOT and LTA, which sets the regulatory framework for PHC drivers. For example, LTA already requires all individuals to pass a medical examination before they can apply for their PDVL, or the Private Hire Car Driver's Vocational License. And I'm sure these regulations will continue to be updated and reviewed by MOT and LTA. Next, Associate Professor Tessera, Mr. Chen Shomao, and Mr. Saktiandi, I think, highlighted the need to consider this increase in people who are self-employed in light of the gig economy. And all of the members rightly highlighted the concern that such self-employed persons may value more their take-home pay and put in less for their longer-term needs, be it for medical needs or for their retirement. I think Associate Professor Tessera said this is actually a broader issue for another day, and truly it is, because it is a bigger issue than the amendments that are being contemplated in this bill. The government is very mindful of this issue, and that's why we have mandated to start with MediSave account contributions by self-employed persons to ensure that they are able to meet their basic healthcare needs. And as several members have highlighted, Ministry for Manpower announced at this year's Committee of Supply that the government would be implementing a contribute as you earn model for self-employed persons' MediSave contributions, whereby a MediSave contribution is required as and when a service fee is earned. Under this model, service buyers or intermediaries who contract with the self-employed person will deduct and transmit the MediSave contribution to the person's MediSave account whenever they pay the self-employed person. The government as a service buyer will take the lead. So we will implement the contribute as you earn model starting with a pilot by 2020. And this will allow the government to work through the implementation issues and help smoothen its subsequent implementation in the private sector. Of course, the issue is a far bigger one than just looking at the MediSave contributions alone, as many members have highlighted. So we will continue to look at different options, including incentives where necessary, to better ensure the retirement of Singaporeans who are self-employed. Both Mr. Louis Ng and Mr. Saktiandi Supat asked some questions about IRAS's powers to investigate tax crimes. So let me just address some of the questions they have raised. In general, investigations of tax offences are conducted by IRAS officers. In cases involving both tax evasion and other offences such as money laundering or corruption, IRAS may engage the relevant agencies, be it the Commercial Affairs Department or the CPIB, to conduct joint investigations. As I had mentioned earlier in my speech just now, the enhanced investigative powers in the amendment bill will be exercised only by authorized IRAS officers, and they will undergo training on the use and escalation on force and various other techniques that are relevant to the exercise of these enhanced investigative powers. The training programs are similar to that received by officers of other law enforcement agencies. Mr. Ng asked if it's similar to that by the police force, because I only mentioned customs as an example just now. I would like to assure him that it is indeed similar to the training received by officers in the police force as well. As mentioned earlier, the safeguards will be legislated to ensure that these enhanced investigative powers are properly exercised. These safeguards are consistent with those applying to other law enforcement agencies. For example, the power to arrest without a warrant may only be exercised for an investigation of serious tax offences like tax evasion, or where a suspect attempts to destroy evidence with a view to hindering or obstructing IRAS's investigations. In addition to these legislative safeguards, there will be clear guidelines and operational protocols on situations which allow for the exercise of these powers by authorized trained tax investigators. Together, these measures will ensure that the enhanced investigative powers are properly calibrated and only exercised when other means are found to be inappropriate. Mr. Saktiandi asked about interrogation rooms and holding centers for suspects. There are already interview rooms in IRAS currently, specifically catered for the questioning of suspects. In situations where the subject under investigation is required to be held for a longer period, he or she may be escorted to facilities in the police force. Mr. Deputy Speaker, let me conclude. MOF will continue to review our tax regime and our schemes regularly to ensure their relevance and effectiveness. The changes to tax regime for the PHC drivers and enhancements to IRAS's investigative powers are the results of such policy reviews. I thank the various members who have spoken on these issues before. We have taken in your feedback. We have put in place these changes, and I believe they are for the better. Thank you, Mr. Deputy Speaker. I beg to move.
The question is that the bill be now read a second time. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Income Tax Amendment Bill.
Minister, committee, what stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 50 stand part of the bill. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. Second Minister for Finance.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of their opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Income Tax Amendment Bill. Item 3, the Building and Construction Industry Security of Payment Amendment Bill, second reading.
Order. I propose to take a break now. I suspend the sitting and will take the chair again at 4:25. Order, order.